Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Each week, Joey answers your questions about the law and how it affects you.
Joey, let's say I'm pulled over for a DUI. What offenses can I be charged with?
In strictly the DUI realm of charges, there are 5 DUI charges in Mississippi you can be charged with. You have the DUI refusal, which means you refuse to take the test. You have a DUI first offense, which means this is your first offense DUI. You have a DUI second offense, which means this is your second DUI within a 5-year period. And then you have a DUI third offense, which means this is your third DUI or more in a 5-year period. And lastly, you have an aggravated DUI, which is actually a felony in Mississippi along with the third offense. And the aggravated one means that you hurt somebody, essentially, whether it was in an accident or something along those lines, and you were drinking above the legal limits.
Okay, so let's say it's my first DUI. Can the officer take my license?
Not only can the officer take your license, he or she will take your license. They will take your Mississippi license. They will hand you a piece of paper that says you have 30 days to go to trial or your license will be suspended. What that means is you have 30 days to get an attorney, have the attorney try setting it for trial. In the event the court cannot hear your case within 30 days and you are not trying to drag it out, your attorney can move to have the time period extended until the date that the court can hear your case. But your license will be taken at the time that you are arrested.
Can I represent myself during proceedings? How does retaining a lawyer help me?
I always tell everyone I can go replace the engine in my truck, but I'm probably going to mess it up because the cold hard fact is I'm not a mechanic. You can go and represent yourself on your own DUI charges. In fact, anything that is legally related, you can represent yourself on. Now, should you? The answer is most definitely no, you should not. I've seen more people convicted in courts trying to represent themselves, and it's not because they are illiterate or anything like that. The cold hard fact is they don't know the law. They don't know the rules of evidence. They don't know what the Supreme Court ruling says operating an automobile means. As an attorney who practices in DUI, these are the things I keep up with. These are the things I leverage for all of my clients to get them the best possible outcome. So while you absolutely have the right to represent yourself, it's one of those situations where quite often you're better off and it's cheaper to go ahead and hire an attorney from day one who knows what they are doing in the DUI world.
What's the cost?
The cost varies. It depends on the charges. It's very, very rare that I see just a DUI first offense charge, and that's because they have to have some kind of probable cause to stop an individual. Aside from it being a roadblock issue, there's usually a speeding ticket, a failure to use the blinker ticket, careless operation, some small ticket that goes along with it. But often, not only do you get that small ticket in the DUI, they are also searching your vehicle and looking in it with flashlights to see if there's any kind of drugs or drug paraphernalia. So quite often, people will have 3, 4, 5 charges going along with a DUI. And the more charges you have, obviously the cost goes up exponentially. But there aren't many reputable DUI attorneys that will handle a DUI case in Mississippi for less than $2,000. And that's simply because you don't know how much time you're going to have to put into it on the head end. I might show up in court and be able to have the trial or resolve the issue within an hour with the prosecutor. And there have been times I've sat in a courtroom for 10 hours just waiting for my case to be called. On top of that, there's the legal research realm. There's the prepping the client realm and explaining them all their options, because as an attorney, our job is to give the client all the information and let the client make the decision on which way they want to go. And then we, as the attorney, direct the case in the direction that the client wants it.
What are some of the defense options?
There are a lot of defense options with a DUI. You have to start by looking at the reason for the stop. Did they have reasonable suspicion or probable cause to stop the individual? From there, the officer has to be able to articulate that he smelled the odor of intoxicating beverage is normally the language they use, or they observe the individual with some impairments, slurred speech, things like that. And then they're going to have quite often the field sobriety test. But the officers, as I've mentioned before, these tests are designed for people to fail, and they're quite intricate and difficult to explain. And quite often, officers miss the cues, or they mess up the cues, or they mess up the standardization of the test, which would make the test invalid. From there, you have the breathalyzer. The one that they give you on the side of the road really doesn't matter. Its sole purpose is for probable cause. What's going to matter is the big one at the police station. Is the officer certified on that machine? Has that machine been certified as being accurate? When was the last time that machine was calibrated? And all those are things that a DUI attorney will just work his way through all the way up to your day of trial. If an officer doesn't show up for trial, well, you have a right to confront your accusers. And in this case, your accuser is the state who is represented by that police officer. And that is a defense to have your case dismissed. So there are a multitude of defenses in a DUI case.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Ridgeland, Mississippi. Call attorney Franks for a free consultation at 601-773-7777. His website is thefrankslawfirm.com.